Therefore, an executive order and or an agency action or an executive action which bans under all circumstances a face mask mandate for school children without a parental opt-out does not meet constitutional muster because such action exceeds the authority given to the defendants under the Parents' Bill of Rights law passed by the Florida legislature. Seeking to enforce a policy through the executive order and through actions that violate the provisions of the Parents' Bill of Rights is by definition arbitrary and capricious because there is no reasonable or rational justification for not no reasonable or rational justification for not following all of the provisions of a duly enacted and authorized Florida law. A policy or action which violates the Parents' Bill of Rights cannot be lawfully enforced by the defendants. The executive order and or agency action as described above and heard in this case, which violates the Parents' Bill of Rights, exceeds any authority to issue the executive order to the extent it sets in motion or causes a violation of the Parents' Bill of Rights and exceeds the authority of the defendants that was granted to them by the legislature in the Parents' Bill of Rights. An executive order ordering or setting in motion a violation of the Parents' Bill of Rights is without legal authority. Further such action, in other words, ordering something or taking an action which is a violation of a Florida statute, is by definition arbitrary, unreasonable, and violates the separation of powers doctrine because it would exceed the powers granted by the legislature in the Parents' Bill of Rights because such action would not permit the school board authority, which has adopted a mask mandate, to demonstrate the reasonableness of it, whether it was necessary to achieve a compelling state interest, is narrowly tailored, and not otherwise served by less restrictive means, all of which is expressly permitted by the legislature in the Florida Bill of Rights. As previously stated earlier in this order, a school district adopting a policy such as a mask mandate is acting within its discretion. It has been given this discretion by the Florida legislature in the Parents' Bill of Rights. So long as the requirements for the policy provided for in the Parents' Bill of Rights are met, I'm not saying the legislature has unbridled discretion. They can't just do, the school boards, they can't just do whatever they want to. They can't do that. They have to meet the requirements the legislature set forth to authorize them to take certain acts involving education and health. But so long as they do that, the doctrine of separation of powers requires that the discretionary power exercised by the school board cannot be interfered by the judiciary or by the executive branch of government, and neither the judiciary nor the executive can substitute their judgment for the school board's power.